Well, may I permit to mention two intercourt appeal, which I mentioned on 14, to place the matter on 18. But your lordship are pleased to direct to appear the matter 25th. Parsi is appearing, my lord, in this matter.
25th, there is a difficulty, sir, because of there is a building inauguration
Yes.
in Howrah, so I will be delayed. And there is another conference. I have to catch a flight at 3 p.m.
Then, my lord, any date convenient to your lordship, my lord, on Friday.
You first get a couple of dates from just Mr. Pardiwala.
I have taken the date, my lord. The next Friday, he is available. On 25th next week.
That will be 1st of August.
Yes. If subject to your lordship pleasure, my lord, if it is placed in
Yes, 1st of August.
Yes.
Lord, may I have your lordship can leave to mention one matter, my lord, under accompanying circumstances. My lord, appeal, my lord, Group 9 appeal of 2023. But I have challenged the order of Honorable Justice Mantha. Now, as per the roster of determination, my lord Justice Mantha is taking the Group 9 appeal of 2023.
You give the letter to OSD.
My lord,
You
may
give this letter to the OSD. Anjani, tell him.
as your lordship.
Yes.
Lordship, may I mention one matter? The matter was actually heard by your Lordship and Honorable Justice Hiranmay Bhattacharya, and this is a contempt application. The contempt matter is pending for a long time. It's for an unauthorized construction, my lord, and the unauthorized construction is continuously
Next week,
going on.
try to constitute a bench. Next week.
Grateful, Lordship.
Original side daily list item number 1, new application.
Service complete?
My lord, service has returned, but I'm told that Mr. Abhijit বিশ্বাস told that they will appear and learned senior will appear in this matter. My lord, there is a delay of 393 days delay. Why delay, my lord? We have explained, my lord, in our application for condonation of delay, my lord. From page number 2, para 2 onwards, my lord, we have explained. More importantly, my lord, para 12. Because the at that point of relevant point of time, my lord, the concerned assistant commissioner was holding the additional charges, and that was placed in that at that point time, my lord, e-office was introduced, and that was uploaded in e-office. Subsequently, when new incumbent has taken the charges, all these things, my lord, subsequently the matter has now thereafter, when we have received an RTI from the respondent, thereafter department has taken steps, whatever what about this order or what is the action taken subsequent by the honorable tribunal's order. কপিটা নিয়ে কোথায় চলে গেল? ঠিক আছে, ঠিক আছে, খালি তো ডিলে করাচ্ছ। হ্যাঁ, ডিলেটা করাই জয় সাহেব।
But the tribunal followed an Ahmedabad bench decision.
Yes, my lord. The thing is that, my lord, here the issue is that inputs are that irregular availment of
this matter, my lord. To be very honest, I was not there in the tribunal stage also. Even now, I do not know. Last night, the client saw the matter in the list. They rang me up and said that tomorrow, if you can have the brief collected and then fix a date, and we'll have come and brief you.
So you served papers?
My lord, I have given the copy.
He has given the copy this morning, so we have taken the copy.
But 393 days.
My lord, the thing is that may just submit cracks issue, my lord.
So let them get.
Yes, yes.
Who will accept? Who will file wakalatnama?
Abhijit Vishwas.
We have heard Mr. So-and-so learned advocate appearing for the appellant department. Mr. So-and-so learned advocate accepts notice for the respondents and seeks time to file wakalatnama and get instruction. List the matter after 2 weeks.
2 weeks, my lord. Keep grateful, my lord. কাগজ দরকার
Item number 2.
For the respondent.
Yes, agreed.
Yes.
I'm led by Mr. Obro Majumdar, your lordships. There's a delay of 148 days.
148 days. That Manasi won't object. What is on merits?
Uh,
You lost right through. Adjudicating authority, appellate authority, tribunal.
the tribunal has partly held in my favor. However, there's a short issue. If I may pray for a
Today
short
we,
pass
today
over.
we will condone the delay and then take up the appeal summons.
Along with that, a copy, if maybe directly served to me, because it has gone by post, so it has still not reached. I have been instructed that although it is their matter, and I'm not opposing the delay. my lord.
We have heard so and so, so and so.
Deeply.
There's a delay of 148 days in filing the appeal. The learned senior standing counsel appealing for the respondent vehemently opposes the delay. We have considered the averment set out in the affidavit filed in support of the application, and we find that sufficient cause has been shown for not preferring the appeal within the period of limitation. That of our, the delay is not inordinate. In the light of the above, the delay in filing the appeal is condoned. GA 1 of 2025 is allowed. Let the appeal come up for admission after a week.
Oh, I'm grateful.
Item number 3.
And for the respondent, my lord.
For the appellant, I'm seeking for an accommodation. I have only served upon them last
Yes.
evening, but my learned friend has appeared. I can.
I have been
appeal
instructed, my lord, because it is against the state order, my lord. So they have instructed me.
We'll condone the delay.
My lord.
We have heard so and so. Same orders. Delay condone.
I'm ready.
Item number 4.
My lord, this is my matter, my lord, on exactly the
Yeah.
same substantial question of law. My lord is hearing a matter of mine, my lord. There is a delay in this case of only 29 days.
And which is that matter we are hearing?
My lord, it is duty paid through scripts, my lord. Whether it is a duty
and Casta 17.
Casta.
Where is it? When is it to be listed?
My lord, it was supposed to be listed today, my lords. I'm carrying the order, my lords. Casta 16 and 17.
The number
बिल्कुल ले तो
এটা আমার হাত
सेम ही है 455.
But it's a different SSC.
Oh, my lord, same as
same SSC, my lord. Orders are different, my lord. So the customs appeal numbers has been different almost, and the dates are different. But substantial question of law, my lord, same. My lord.
There is a delay of 29 days. Please condone that and list this appeal along with Casta 16 of 2025 next week.
Next week.
May kindly keep it on 14th of August because Mr. Ghosh was supposed to travel today, but the matter was not there in the list. So he has indicated it 14th of August, pleases my lords.
14th is
14th is difficult, sir, because 15th we have got a mega program here.
So, my lords, then
After
28th of
15th.
August, if it pleases my lords. 28th of August.
Choose a date after 15 September.
My lords, because that is the dates which he has given to me. My lords. Otherwise, whatever
All
dates.
right, 28th of August.
My lord, deeply obliged.
Both the matters.
My lords, 6 and 7, my lords, has not.
My lord, 5 have not been taken up.
Sorry.
Five,
Item
my
five.
lord, same, my lord. Same date of delay, my lord.
And 28 days delay.
29 days, my lord.
5 also delay condoned, list along with.
And my lord, with respect to 6 and 6, my lord,
Hmm.
the delay that is,
Item number
I think
6.
my lord, that delay is 455 days delay. My lord, the same substantial question of law, SSE is same, only date is different. My lord, the reasons why the delay happened is the sister order was communicated to the legal department that they will prefer an appeal from the tribunal. It is only the 16th of January 25, my lord, because before that day they were in a mental fix that what to do, because there are other matters that is coming from the
But
sister.
why was the delay in communicating the order?
My lord, that I
From the
interdepartmental thing, my lord. And when it came to their knowledge, immediately they have appointed councils. Now, my lord, the previous council, there are, because of some difficulties with respect to filing, he rejected. So, new set of council, senior has been me, but junior has been somebody else. So,
But why don't we other matters, same issues?
yes,
but-
my lord. And on this,
My
my lord,
but my lord, I don't even have a copy of this
my lord, I,
6 and 7.
my lord, can,
And my lords,
my lord, I have a
there is a
copy for
substantial.
7, how many days delay?
my lord, same, 6 and 7, 6 and 7, same.
455 days.
455, my lord. My lord, for this, my lord, I would like to rely on.
But you want to file an affidavit?
My lords, on this 6 and 7, my lords, this substantial delay, poor and my lords, if my understanding, because I don't have a copy of the brief, my lord, but
Suppose we dismiss this appeal on the ground of delay,
yes, my lords.
then automatically the order of the tribunal stands.
My lord,
Yes, my lords, and that,
Then the other appeals have to be
Others.
dismissed.
my lords, if I mean, if that is the case, that the first or the parent order from the CSTAT, if they sat tight over that, my lords, for a good long
This
period,
is the parent order.
my lords, that is my assumption, because I have not
Right,
been served
then
the
you-
brief.
Then you file a use an affidavit and
Absolutely, my lords.
we have heard so and so, so and so.
deeply
It
obliged.
is submitted that in the other appeals concerning the very same assessee, there was marginal delay in filing the appeal, which has been condoned, and the matter has been listed to be heard for admission. And since identical substantial questions of law have been raised in this appeal, the learned advocate appearing for the appellant department prays that the delay may be condoned. And what judgment you are relying on?
My lord, it is my lord's own judgment, my lord, wherein my lord has said this is this being a technical issue may be condoned for the reason of there are substantial question of law that has to be adjudicated by my lord. Yes, yes. Soft copy, please, sir. My lord, the first paragraph, my lord, there is a delay of 627 days in filing this appeal, and the revenue has filed GA1 of
Wait,
20.
The learned senior standing counsel appearing for the appellant place reliance on the decision of the division bench of the court in the case of Principal Commission of Income Tax versus Surajmul Nagarmul, IT-80 number 46 of 2020, dated 23/11/2020. The learned advocate appearing for the respondent submitted that the respondent may be granted liberty to file an affidavit in opposition. Let such affidavit in opposition be filed within 2 weeks from date. Reply, if any, within 2 weeks thereafter. List this appeal along with other matters on 28th August.
My lords.
Deeply obliged. Deeply.
Much obliged.
From which college they are from?
The delay copy.
হয়ে গেছে, লিখে নিয়েছি আমার।
You are from which institution?
Which institution?
Legal Aid Services West Bengal, sir.
Legal aid?
Legal Aid Services West Bengal.
Justice Dilip Kumar.
Justice Dilip Kumar Bastu's organization chairman, sir.
And all of them are postgraduate diploma.
Postgraduate diploma course in counseling.
And then some of you can come in the front.
So I
Vajpayee was also the senior advocate, was there of room number 2. We participated. The first ever Lok Adalat of Calcutta High Court was organized, and we were then the students. As para-lawyer, we participated in that program.
And please tell us something about your course. Come in front.
It's actually about the counseling course, and we are from different background. Some are from psychology background and many are from different background. All we are here to learn about the counseling, and in law it's counseling is a very important matter. So we all are learning how to counsel, and we are learning that.
Oh, after you complete this course, will you be absorbed in the government service, or will you, because in our family courts, counseling is mandatory.
Sir, Milord, probably our absorption or role will be in the family court mainly, not as a lawyer, definitely, but we can bridge up the gap of mitigating the things through counseling, so it not pile up in the court of law. So,
How many of you are psychologists? Psychology degree you have got?
Sir, I have done masters in psychology.
We are currently hearing a matter concerning rare diseases, which includes muscular dystrophy among children. It is a degenerative disease. Over a period of time, the children will not be able to walk, etc. They'll be wheelchair bound, and their lifespan is also very limited. Yes. Now their treatment is being done in a center of excellence in the Calcutta Police Hospital.
Okay.
Suppose some of you are willing to counsel the parents.
Yeah, I am very willing.
we'll be very keen to.
I will be very glad that
Actually,
Will be glad. All right. Then our court master will give you the phone number of Madam Nandini Mitro.
Okay, sir.
She appears for the Muscular Dystrophy Welfare Society.
Okay, sir.
To get in touch with them. In fact, one of our High Court officers, his son is also affected.
Okay, sir. So that will be our pleasure to serve them.
You can do that.
Yeah.
And we will get you a permission from the head of the Department of Neonatology.
Neonatology.
Neonatology. Yesterday, what is her name? You remember?
The Supreme Court.
Dr. Sunanda.
The order sheet and
He is also the nodal officer for the Center of Excellence, SSKM Hospital.
Okay, sir.
She was present yesterday.
Pathok cancer.
Pathak will.
That is the physiological problem also, and we will serve our best by psychological side.
Second is in the correctional home, especially under trial.
That, yeah.
Some of the
Underage crime is the
on the what is that?
And the juvenile homes.
Juvenile homes.
juvenile groups.
When the juveniles come in conflict with law, they are there. That's also a good place where you can help us.
That will be our
That
pleasure
will
to
be our
serve.
pleasure, sir.
There is a juvenile justice committee
Okay.
in the High Court, and there is a secretary.
Indula and with Pile Banerjee, the junior minister.
File.
They can contact with Archie and from there only.
You can contact Registrar General.
Okay, sir.
Our officer from the High Court, he will take you.
Okay, if someone guide us, we will.
So you partner with them, and you can help them out.
Sure, sir.
And there are other people who are convict prisoners who are in the correctional home, especially women.
Yeah.
Like they are undergoing life stream, but they have got children. Children are in a home. They are taken to a school, etc. A lot of activities are going on. But those children are under tremendous pressure. Because when they go to a normal school, they come in a police bus. So it sends a different signal. It is coming, why my classmate is coming in a police bus? So there is one thing like that.
That also affects their mental health also.
And you can contact one other person, Madam Alaknanda Roy. You have heard of her?
Yeah. Yeah. Yes, sir.
She has rehabilitated several of the convict prisoners. In fact, we had a conference last year, and she organized a program, dance program, all traditional dances of West Bengal, and all of them are serving lifetime imprisonment in the various correctional homes in West Bengal. If you contact her, she'll also be able to give you avenues where you can assist her or the other psychiatrists and psychologists.
Okay, sir.
So after your visit, you meet the Registrar General, Madam.
Okay, sir.
And then make a proposal.
Okay.
Okay, ma'am.
Should be through official channel.
Of course.
Okay, ma'am.
Saying that our students are willing to partner.
Of course, sir. That is our duty.
These rare diseases, you can always make a request. We'll put you on to Madam Mitro.
Okay.
You get that phone number and give. Nandini Mitro.
Okay, sir. We will collect that, and we shall be glad to come those children to the mainstream of the society.
It's our pleasure,
Parents
sir.
are under tremendous pressure in the sense they can't do any other work. They have to stay with their child throughout the day.
Sure.
In fact, one of the lady who comes here, both the children are affected. They are studying in Kendra Vidyalaya here. Her husband has stopped and stays in the school with the children from the morning till the evening and brings them back. Everything has to be so the parents are under so much of pressure. Right. Thank you.
Thank you, sir.
Thanks, sir. Thank you, sir.
Next.
Item number 8.
Well, there is a delay of 38 days in both the appeals.
But I have no problem in delay, but the appeals are not maintainable. For monetary limit, if your lordship can you come to page
We shall take instruction on the next.
and at page 46, this is second appeal, commissioner appeal,
Page
46. That is the order in original. Though value is not relevant, but still value is also less than 1 crore. 2930. All penalties are less than 1 crore, individual penalties. Thereafter, commissioner appeal, we preferred appeal, commissioner appeal held in our favor, decided in our favor. If your lordship comes to page 68, on merits, commissioner appeal decided in our favor. Thereafter, they preferred the appeal before tribunal. Tribunal again upheld the order of the commissioner appeal. Against that, they are before your lordship, which is all appeals.
But in the circular issued by the CBEC, there is no exception.
No,
over here,
only refund,
Malad-
refund, recurring,
No, unlike CBDT instruction.
Malad, three exceptions: constitutional validity, notification, instruction, order or circular, illegal or ultra vires, and third, classification and refund case. If your lordship kindly allows me to place that. This
Malad, we have specifically pleaded, lordship will kindly see page 19, paragraph 28.
They have refunded my pre-deposit also.
Oh, they have refunded.
They have refunded.
Malad, that is a different issue. Otherwise, we will be incurring interest, Malad. You will be asking us to pay interest and keep the money.
Anyway, I have showed your lordship that this is below the
Malad, paragraph number 28, we have referred to a.
So it says that you are referred to Meghalaya High Court judgment.
And also, Malad, there is one. This is the Meghalaya.
May I have a copy?
Yes. My lord has decided if there is substantial question of law, then appeal is made.
And there is substantial question of law which is to be decided by your lordship, and as such, your lordship has jurisdiction. Your lordship has held.
You can ask. Internal table can
That's pulling it.
My lord is the very initial question of input is maintained. আর আছে আমার সর্বমঙ্গলা গজানন What is passed out? Section 27, 2021. Section 27, 2021.
Section
27. 21.
Have you got the 2011 notification?
Yes. 2011 notification. 17/8/2011. Photo copy of Malad. Over here, your lordship will find paragraph 2. একটা কপি দেন অনেকবার দিয়েছি আরেকবার নেই কেন এই কপি ধরো for ascertaining whether a matter would be covered within or without the aforementioned limit, the determinative element would be duty tax under dispute. To illustrate it further, in a case involving duty of rupees 5 lakh or below with equal amount of penalty and interest, as the case may be, no appeal shall be filed before the tribunal. Similarly, no appeal shall be filed before the High Court if the duty involved does not exceed rupees 10 lakh with or without penalty or interest. Further, the commissionerate shall not send proposal to the board for filing civil appeal or special appeal in Supreme Court in case involving duty up to 25 lakh, whether the penalty with penalty and interest or not. Well, the next sentence is very important. However, where the imposition of penalty is the subject matter of dispute, the said penalty and the said penalty exceeds the limit prescribed, then the matter could be litigated further. Similarly, where the subject matter of dispute is the demand of interest and the amount. So, my lord,
My
where
lord,
there is
over
no
here-
demand of duty,
My lord, over here, the smuggling is the main issue.
then, my lord, the
We
next
have we have got
my lord, senior will kindly allow me to make. Then the 2014 came. Kindly see, 2011 was modified by 2000, clarified in
if it is
2014.
legally importable, then the dispute with regard to the duty penalty
Very
will
well,
be
you
the
have your own time.
But the order in original directed absolute confiscation.
yes.
Absolute confiscation.
But without any right of redemption.
Right. If had it been redeemed, then the question of redemption fine along with duty under 125(2) would have come. Had he redeemed it, because duty under subsection 2 of section 120, well, kindly see 2014 clarification. It is the clarification of 2011. Kindly see para 4. The instructions mentioned above use the word case. However, the same was not defined. The term case needs to be interpreted in the context of national litigation policy, which aims at reduction of litigation. In respect of a composite order which disposes of more than one appeal, show cause notice, and the department contemplates filing of appeal, every appeal would be a case and should be subjected to the threshold limit prescribed. So, my lord, here I'm putting a question to myself. If your lordship comes to page 46 once again of the stay petition. Even if this case is considered, the value is not a subject matter. Even if page 46, order, paragraph 7.1, order of absolute confiscation of gold, valuing 64 lakh, belonging to, kindly see the
Foreign
last
origin.
sentence, Sri Anil Kumar Gaur. So the value of 64 lakh would be relevant even if your lordship goes by that to Anil Kumar Gaur. Rest, kindly see 7.4. Anil Kumar Gaur is 6 lakhs rupees penalty. Then 7.5. Anil Kumar Soni is 6 lakhs rupees penalty. So even if the national litigation policy is taken into consideration in each case of Anil Kumar Soni and Anil Kumar Gaur differently, both are below the threshold limit of 1 crore. And what is this case? I have won before the commissioner appeal. They have gone before the tribunal. Tribunal rejected their appeals. Now they are in second appeal. They are saying about the confiscation and smuggling that has been held to be not correct by the commissioner appeal.
Well, a statute has
And they
given us
cannot
the,
interpret the national litigation policy.
well, over here, the issue is with regard to the smuggling. The monetary limit, if it is legally importable, then the duty and penalty will be an issue. But over here, it is smuggling
If
read
it is
with one.
legally imported, then where comes the question of penalty?
Well, let him complete, Malad. It is my appeal.
Well, this
Malad,
circular does not
123
classify anything.
123 is the burden of proof which has not been discharged by the respondent herein, nor the tribunal has discussed the same. Over here, my lord, if your lordship sees the order, it has been the specific case of before the adjudicating authority that which was illegally imported into India through unauthorized route and manner, and subsequently procured and carried without any valid documents. So he is the second holder. First is the legally importable item. So it has been held by the adjudicating authority after consideration of all their documents, their justification and their memos, which says that they are not, there is no cogent reason to satisfy that the gold bars which have been found at Howrah station by their carrier is that legally acquired gold. Now subsequently the appellate authority says there might be mistakes and mismatches in their document.
But did he produce any invoice or anything?
Yes.
They have been produced, which have been dealt with by the adjudicating
We
authority.
see page 61.
Well, let me take my seat.
And this judgment has become final. Nobody is taking
No,
it
Malad.
on.
No.
Huh?
Still have
far
not
as
received
knowledge,
instruction.
I have seen it for the first time, Milord.
October
let him take-
2020.
let-
Yeah, I have given the.
I have seen this for
Let
the
him
first time.
verify.
We'll hear you out.
Yes, Malad. We shall come.
We have heard so and so and so and so. The learned advocate appearing for the respondent assessee raises a preliminary objection with regard to the maintainability of the appeal on the ground of the monetary limit. And in this regard, as referred to the circular issued by the board dated 17th August 2011, 26th December 2014, and 2nd November 2023. The learned senior standing counsel appearing for the appellant places reliance on the decision of the Honorable Division Bench of the High Court of Meghalaya in Customs Appeal number 1 of 2024 dated 22/10/2024, wherein similar objection was raised on behalf of the respondent therein. And the court held that the circulars issued by the central board will not cover cases of smuggling and cases where the adjudicating authority ordered confiscation of the smuggled goods, which is gold. The learned advocate for the party take time to make submissions in the matter. List after 2 weeks.
Well, delay may be called. Delay.
How many days?
38 days.
All right. First delay you can control.
For it to 58 days.
This is 8 and 9.
8 and 9. Same. Both 38 days. Grateful.
এটা আপনার স্যার মনে হয় এটা কপি আপনার আপনি রাখুন
Grateful.
Obliged.
Okay. Notice of who he lady. Abu Hina means lady. No. Okay.
For admission of tax matters, item number 10.
Your Lordship, I'm being led by my learned senior, Mr. Bagh, in this matter, Your Lordship. On last occasion, we were directed to file affidavit in this matter. An affidavit by the assessee explaining as to why we did not attend.
Because the assessee was blaming the advocate.
Lordship, the explanation has been rendered in this affidavit. We've already served. We'd like to file a
That
copy.
affidavit. Let them go through.
Well, I have gone through, my lord. My lord, their contention is that, my lord, the recording of the tribunal, that, my lord, some 18, my lord, times adjournment has been taken. My lord, their affidavit, my lord, shows, my lord, after annexing the, my lord, the orders of the tribunal, it shows, my lord.
No. Today, let her file the affidavit.
Lordship.
Let Mr. Bagh come. We'll
Lordship.
take it up. In terms of the directions issued earlier, the appellant has filed an affidavit, copy of which has been served on the learned advocate appearing for the respondent department. List the matter after 2 weeks.
Lordship. Deeply obliged, Your Lordship.
Item number 11.
And for the respondent.
Lord, on the point of tax limit, this is accommodation loan, and I'll show the circular, my lord. Circular. Circular. Circular cricket. Circular. उससे निकल के not that. Circular. Then that's okay.
Break it up.
Deal.
ठीक है
My lord, in identical matters, my lord has passed a judgment in PL Goenka. Identical matters. चलो है था चलो ठीक है
No, the tribunal has followed some coordinate bench decision.
Yes, my lord.
In Namokar.
My lord.
What happened to that matter?
My lord, you aware about Namokar?
It has only extracted the entire judgment.
Yes.
Allowed the appeal.
Extracted the entire judgment. My lord, on the scripts that Namokar had specified, on those scripts, PL Goenka is also there, my lord, which my lord has passed that judgment. Tuni textile, etc., is what Namokar is based on, my lord. My lord, will kindly take a look of. একটা ওকে ওকে দেখতে তো হবে এরকম করলে কি হবে
PL Goenka HUF was Puni Textiles.
Tuni textiles. Here also. Namo is also Tuni textiles.
Show from the extracted portion.
My lord.
Where is this Tuni? Have you filed an appeal against this Namokar?
No appeal has been preferred.
That question was
Has
put
been
to him
preferred.
earlier.
Has
At
been
that
preferred.
time,
Has
he
been
had
preferred.
indicated that they have gone under the settlement scheme. That is what he had indicated on the last date.
They had gone on a settlement.
Namokar has gone.
Namokar has gone on a settlement.
But you filed an appeal.
Yes.
Yes.
But the tribunal did not discuss any facts.
But if I may just draw your lordship's kind attention to one finding, Millet.
No, assuming a
Yes.
single bench of this court passes such an order, will you not be there on appeal?
Millet, kindly have a look at paragraph 7. Millet, I do follow that.
Cite a decision. First, the decision has to be applied to the facts.
Yes.
So the facts needs to be discussed. What he does, records the authorized representative submission, records the DR submission.
Yes.
Then he says, as observed earlier, the matter is squarely covered.
Similar to
20 pages, he extracts his judgment. And last paragraph, he says, tribunal says, case before us are substantially similar. We are therefore respectfully following the above decision of the coordinate bench and set aside the order of CIT.
If your lordship will kindly just come to
And Millet-
paragraph 7 once. Millet, I do follow what your lordship is indicating, Millet.
Some discussion should be there. How this judgment applies. This was also concerning the very same company where scripts was there. Merely because you can always argue there may be a stigma attached to stocks called penny stocks.
Yes.
But nothing prevents a person from dealing with penny stock.
Right.
But here are cases where they are artificial claims are made, prices are unreasonably boosted to probably avail unintended long-term capital gain or short-term capital. So you have to clear the facts. Say, yes, it may be a penny stock. Still, please look at my books of accounts.
Yes.
I have done this trading. I have done this, and these are all the things. And this is the reason you see how the price rise was there in the market. That particular company had net worth of so and so. They had regular production activities. Nothing is there.
In fact, those details have been given by the commissioner.
He has done a
Yes.
very elaborate exercise. You want to refer para 7?
Yes, paragraph 7.
Please.
May I place it? After hearing the rival contentions and perusing the materials on record, we find that the SSC has been engaged in dealing of shares and securities during the year. We note that out of the total business done during the year, the SSC incurred loss on 2 scrips, namely Redford Global Limited and Srinath Commercial Limited, which was set off against the income earned by the SSC by way of interest. The interest income was rupees 31 lakhs 43,618, whereas the loss on these 2 shares was rupees 51 lakhs 33,870. We note that the AO has only relied on the report of the investigation wing stating that these companies were engaged in providing accommodation entries without doing any real business, and thus treated the loss as bogus without bringing on record any substantive evidence corroborating the fact that the SSC was in fact involved in the wrongdoing. This is the portion I wanted to highlight, Merit. Kindly appreciate one thing. Merit, if your lordship will have a look at the circular which he is relying on, kindly have a look. But he proposes to put me under 3.1H. Kindly see what 3.1H says. It covers cases involving organized tax evasion, including cases of bogus capital gain or loss through penny stocks. But I do not fall under this. Mine was a business loss. And cases of accommodation entries.
Yes.
So far as accommodation entries are concerned, Millard, there is nothing specific against me. There was a report of the investigation wing saying that certain people had admitted that they were involved in the rigging of prices of shares of these two companies. And they had also stated that they had provided accommodation entries. But there was nothing specific against me. Now, Millard, the inclusive portion, which covers two things, do not apply in my case. So they propose to put me under the broad head, cases involving organized tax evasion. That is the broad head under which they propose to put me. Now, Millard, in view of this finding of the tribunal, that there is no specific evidence against me showing that I was involved in any wrongdoing, Millard, this is a finding of fact. And importantly, Millard, this is a finding of fact they do not challenge in their appeal. But if this finding of fact is allowed to stand, in my humble submission, they cannot possibly suggest that this is a case involving organized tax evasion. Now, if they cannot take that stand, Millard, then I do not fall under the exception in the circular. And Millard, he was relying on that decision of PL Goenka. Millard, kindly see three paragraphs. Millard, kindly come to paragraph 11 once. Kindly see the difference between that case and my case. Paragraph 11 first, Millard. Please. We have carefully perused the assessment order dated 25/9/2021. In paragraph 2, the assessing officer sets out the information received from the investigation wing by the letter dated 6/3/2020. It is not in dispute that the assessor's name also figures in the information furnished by the investigation wing.
It is not there in your
It is
case.
not in my case. Kindly come to the next page now, Millard. Millard, over here, 7th line from the bottom of this page. There's a sentence starting with furthermore. Furthermore, that the transaction in shares of Messrs. Tuni Textiles Mills Limited by the SSE was a pre-arranged transaction in the form of accommodation entries managed through collusive transactions by group of entry operators. This is not there in my case. This is a finding against the SSE recorded in that case. Now, Millard, kindly come to the next page, paragraph 12. That apart, the learned tribunal has not examined the reason set out by the appellate authority, which has re-examined the factual position, taken note of the grounds raised by the SSE and their oral submissions, and has in detail discussed about the borrowing of funds.
It should be laundering.
And how the funds reach the concerned beneficiaries, and has factually found that the SSE is one of the beneficiaries who received accommodation entries, which was used to avail bogus long-term or short-term capital.
Same case here.
Yes. No, there is no finding against me, and that is what the tribunal points out. That is a finding they do not challenge in their appeal. So, Millard, factually, the case on which they rely and my case are different.
No.
And Millard, if this factual finding of the tribunal is allowed to stand, Millard, he cannot possibly take me under 3.1H. And Millard, there's one more thing I would like to point out. Kindly have a look at this decision, Millard.
Now, what was the face value of the share? 10 rupees. You purchased it at what rate?
A minute, kindly.
Honorable, kindly come to the AO.
Yes, it's set out in the assessment order, Millard.
Page
10.
In view of the above, the assessee was asked to submit particulars of so and so. Trading in shares. Perusal of the detail reveals assessee incurred loss of 51 lakhs. Radford Global and Srinath Commercial. Radford Global purchase was 40,000 shares.
Value is of 32 lakhs 394. So that approximately would come to Millard 80 rupees.
And sales was 55 lakhs 8,000.
No, 5 lakh 58,000.
Oh, therefore your trading loss was
Yes.
26 lakhs 42.
Yes.
And total was trading loss was 51
51
lakh.
lakh.
So the assessee is an NBFC.
Yes.
Yes.
I was carrying on two kinds of business, money lending and selling and purchasing of shares. In case of these two companies only, I sustained losses.
But you come to the last paragraph in page 10.
Yes.
Since the assessee has incurred huge loss only in the above mentioned scripts, therefore this issue was deeply examined with all available tools, such as through internet and other search engines available on the net, as well as the investigation report of DIT Investigation Kolkata and other agencies.
Yes.
Above mentioned companies has no worth and they are not engaged in any proper business. Strong reason that the prudent businessman will not buy such a huge number of shares of the above. As per the information received so the particular scripts are the list of bogus capital loss claims. Assessee was appraised of the details of the investigation report, allegations made in this. Assessee company's detailed show cause notice on so and so and so and so. Assessee why the reported script should not be. In response, we are surprised the observation also was used for accommodation. Purchased and sold shares in the company normal course of business through share brokers and demat. Payment was through banking charge.
The manner in which the transactions actually took place, that has been spelled out, and that has not been controverted. Their sole objection is this: I was dealing in the shares of these two entities which had been named in the report. That is their basic objection.
This aspect was dealt with clearly in Swati Bajaj. My lord, kindly see thereafter that paragraph. After their reply, the second paragraph after their reply, which is in bold, it was observed that the contracts of buy and sell were being offered at or about the same time by a fixed cartel of brokers involved in a circular manner whereby equal quantity of shares of sale were matched by equal quantity of shares by the persons buying at the same consistent price. The price of the shares in a real market, driven by the forces of demand and supply, legitimate buyers and sellers demonstrate volatility on an intraday and an intra-year basis. The said principle is surprisingly absent in the case of the impugned company. Secondly, the reports made by the investigation department is very thorough and exhaustive. Report made emphatically prove that the transaction made was sham and fabricated. Report supplied further strengthened by the facts and findings as below. So thereafter he comes to his findings on Radford and Srinath. Then my lord comes to page 17. After the chart,
yes,
no genuine business, thin trading volume, low net profit, low EPS, and meager income are some characteristics of these types of stocks. These facts in no way commensurate with the steep rise and fall in the price of the stock. SSE has argued that the said transaction shares are made through registered share broker and are supported by contract notes, etc. etc. The shares were moved through demat account, banking channel, etc. My lord. And thereafter, the investigation identified a total of 84 listed companies, 5,000 paper companies, and 25 entry operators involved in this racket. The statement of the operators were recorded in which they accepted rigging the price of the shares and managing the market to bring desirable results which suited their client. These operators also accepted that they were doing this only for a poultry commission of 50 paisa 1 rupee per 100 rupee. These alleged scripts also follow the uneven pattern of rise and fall and the artifice as discussed and elaborated by the investigation wing report in other tainted penny stocks. These facts prove beyond doubt that the transactions were sham, done through stock exchange to provide a proper veil of or covering. That genuineness could validly be tested on the ground of principle of preponderance of human probabilities, which would thus form a valid ground of or parameter for determining the genuineness stands since settled by the apex court in Sumiti Dayal, wherein the apex court in declaring the transaction as non-genuine discarded a host of documentary evidence filed or relied. My lord, thereafter in the next paragraph, what is genuine should be genuine in all aspects, intention, terms, etc.
What are they?
In fact, the commissioner goes into further details.
But you didn't appear before the commissioner.
No.
No, I did not. But the thing that I was trying to highlight is this, Millard, they do not find anything specific anywhere. Neither the assessing officer nor the commissioner appeals.
No, Sumati Dayal, they have laid the test.
Yes.
Yes.
You are an NBFC, you are earning a lot of interest income. So as a prudent businessman or a person with reasonable business values, will you go and invest in such a company which had no business activities? And as per your return of income, you had shown the total income of the company 1,34,616.
Yes. Yes.
And the investment is running into lakhs.
Yes. But my income came down to
the first objection is monetary limit.
Yes.
It will not be covered under the H. Second is PL Goenka has factually disproved.
Yes, and Millard, so far as the circular is concerned, Millard, I just wanted to hand over this decision to your lordships, Millard. Before your lordships have a look at that, kindly have a look at his substantial questions of law, which are there at page 5 and 6.
In this appeal?
Yes, in my appeal.
Yes.
Let kindly have a look now at the questions which are there at paragraph 2 of the decision, which I have just handed over now.
Paragraph 2.
Paragraph 2.
2.
Yes, that's the questions there.
So those are the questions framed in Bright Star. Kindly compare it with the questions framed
Identical.
here. Now, Millard, the questions are substantially the same in both. In that matter, they did not take the plea that this will get covered by that exception clause.
But that was a case of 68.
Yes.
Section 68.
EST Intratech was being followed.
68 is not a problem. All right, we'll consider the facts and applicability of circular. And according to your cases, it's a genuine business transaction.
Yes. But the aspect that I was wanting to highlight is this. But it is an admitted position that some people have given their statements that they were involved in the rigging of prices of shares of these two companies. They had provided accommodation entries to certain entities. Nobody says anything specific against me. There is no evidence to show that I was involved in any kind of wrongdoing.
No. That is not the allegation. The allegation is those scripts, their values, everything was rigged.
Yes.
And some statements were recorded, and those fellows said for 50 paise to 1 rupee per 100, we are doing these entries. But your conduct in purchasing the shares of this company, that was being tested by.
That is being questioned by.
All right, let us see.
Now, Milord, in that event, let
Milord,
us assume that my assessment at the time of purchasing those shares was wrong. But because of that, malafide possibly cannot be.
No, my lord, his assumption in buying the shares at that point might be wrong. His assumption of selling those shares at a loss at that point of time,
No,
when the
what was
shares
the
at
date
8
of
rupees,
purchase? Date of
Milord,
purchase.
date of purchase.
that 1 year period, that 1 year period is there.
Milord, so far as one
It was
company is concerned,
perfect 1 year.
kindly come back to page 10. Kindly come back to page 10. Milord, so far as Radford is concerned, the entire purchase and sale took place in that 1 year.
Yes.
So far as Srinath Commercial is concerned, 52,000 shares had been purchased earlier. In the year in question, only 5,200 shares were purchased. Kindly see serial number 2, the figures against that. Quantity opening stock 52,000. That was there from before only. In the course of this year, I purchased 5,200 shares. So this is not something that I acquire and sell in this 1 year.
So 2012-13, 52,000 shares.
Yes.
Then 13-14, 5,200 shares.
Yes.
And but you sold 57,200 in the year.
In this year. In this year. So it can very well happen that I decide to take my chance purchasing shares of two companies. Now, in the background, something wrong is going on. I am not even aware of it. I get caught in that because some people were engaged in some kind of wrongdoing.
That is why we adopt in that Swati Bajaj, we said that this sort of matters requires a reverse engineering.
Yes.
You work backwards.
Backwards. And here again, his arguments to an extent might have cut some eyes if it was LTCG. Yes, it is STCL. Why did you decide to sell them at that particular time and to get that benefit?
This is long-term capital loss.
Yes.
Yes.
Short-term capital.
This was my business. This was my business.
This short.
So buying and selling was part of my.
No, my lord will also see that his business, he was not doing anything.
Pardon?
He was not doing anything.
No.
He did not. He was doing.
No, my lord. There is a finding.
No. Assessment order, it says it
I
is
am carrying on
noticed
my
page
activity.
10 has earned interest income to the tune of 32 lakhs 43,000.
I was carrying on activities.
NBFC. He is an NBFC. Page 10, last but one paragraph.
Yes, my lord. But lending also will see during if my lord sees page 10, last paragraph. During
So the shares of Radford were purchased at 79 rupees 85 paise.
Yes.
And 79 rupees 95 paise per share on 18/4/2013.
Right.
From two persons, Dilip Chotalal Mozaria and Suresh Kumar Sukalchand Lodha.
Yes.
Sold on 30th of October 2013 at a price of rupees 14 per share. To Ruchina Merchants Private Limited, barring 10 shares sold to Siddhiman Vyapar Private Limited. SAT has confirmed order of the security so and so for Ruchina Merchants for manipulation in shares of Radaf Global. Adjudication, it is held. Various entities, including Ruchina Merchants, indulge in intra-group trading with manipulative intent. Violation of so and so. MCA data, Abhisit Basu, Pradeep, they are directors. Singet Vinmay, so and so. Others. Okay, we'll consider.
If I may just hand over a few decisions, kindly have a look at this decision of the Delhi High Court. But kindly take paragraph 11. Paragraph 11. If I may place it. On a perusal of the record, it is easily discernible that in the instant case, the AO had proceeded predominantly on the basis of the analysis of the financials of Messrs. Goldline International Finvest Limited. His conclusion and findings against the respondent are chiefly on the strength of the astounding 4,849.2% jump in share prices of the aforesaid company within a span of 2 years, which is not supported by the financials. On an analysis of the data obtained from the websites, the AO observes that the quantum leap in the share price is not justified. The trade pattern of the aforesaid company did not move along with the Sensex, and the financials of the company did not show any reason for the extraordinary performance of its stock. We have nothing adverse to comment on the above analysis, but are concerned with the axiomatic conclusion drawn by the AO that the respondent had entered into an agreement to convert unaccounted money by claiming fictitious LTCG, which is exempt under Section 1038, in a pre-planned manner to evade taxes. The AO extensively relied upon the search and seizure operations conducted by the investigation wing of the Income Tax Department in Kolkata, Delhi, Mumbai, and Ahmedabad on penny stocks, which sets out the modus operandi adopted in the business of providing entries of bogus LTCG. However, the reliance placed on the report without further corroboration on the basis of cogent material does not justify his conclusion that the transaction is bogus, sham, and nothing other than a racket of accommodation entries. We do notice that the AO made an attempt to delve into the question of infusion of the respondent's unaccounted money, but he did not dig deeper. Notices under Section 133(6), 131 of the Act were issued to Messrs. Goldline International Finvest Limited, but nothing emerged from this effort. The payment for the shares in question was made by Sri Salasa Trading Company. Notice was issued to this entity as well. But when the notices were returned unserved, the AO did not take the matter any further. He thereafter simply proceeded on the basis of the financials of the company to come to the conclusion that the transactions were accommodation entries and thus fictitious. The conclusion drawn by the AO that there was an agreement to convert unaccounted money by taking fictitious LTCG in a pre-planned manner is therefore entirely unsupported by any material on record. This finding is thus purely an assumption based on conjecture by the AO. This flawed approach forms the reason for the learned ITAT to interfere with the findings of the lower tax authorities. The learned ITAT, after considering the entire conspectus of case and the evidence brought on record, held that the respondent had successfully discharged the initial onus cast upon it under the provisions of Section 68 of the Act. It is recorded that there is no dispute that the shares of the two companies were purchased online, the payments have been made through banking channels, and the shares were dematerialized, and the sales have been routed through demat account, and the consideration has been received through banking channels, same as in my case. The above noted factors, including the deficient inquiry conducted by the AO and the lack of any independent source or evidence to show that there was an agreement between the respondent and any other party, prevailed upon the ITAT to take a different view. Before us, Mr. Hussain has not been able to point out any evidence whatsoever to allege that money changed hands between the respondent and the broker or any person, or further that some person provided the entry to convert unaccounted money for getting benefit of LTCG as alleged. In the absence of any such material that could support the case put forth by the appellant, the additions cannot be sustained. But this is one decision, Milord.
This was anyway before Swati Bajaj came in.
Pardon?
This decision was passed before Swati Bajaj came in.
Yes.
And there is also one decision of the Orissa High Court, which is quoted in the passage set out by the tribunal. If I may, We'll kindly see para 4 onwards, Milord. The question sought to be urged by the Revenue Department in these appeals is whether, after making certain statements in the survey, the assessee not claiming exemption under Section 1038 of the Income Tax Act 1961 at the stage of assessment proceedings, could the assessee turn around and make such claim of wanting to cross-examine persons making adverse statement against the assessee at the stage of appeal before the ITAT. The impugned order of the ITAT has sufficiently dealt with the factual details concerning the respondent assessees. The question was regarding the claim of long-term capital gains on shares in terms of Section 1038 of the Act. During the course of scrutiny assessment, a revised return was filed by the assessee claiming the above exemption. After the AO rejected the plea, the assessee went before the CITA. The CITA was satisfied that the purchase of liquid shares have been made through account pay checks and the shares themselves were held in demat account for more than 12 months and then sold through the recognized stock exchange after payment of security transaction tax. A reference was made to the CBDT circular, which debarred the revenue from obtaining admissions or statements during the course of a survey. The ITAT also noted the settled position in law that if an assessee has wrongly offered an item of income or omitted to make a claim of deduction in the return, he was entitled to correct such a mistake by making a request to the AO to that effect. In June 22. Another ground on which the ITAT found fault with the additions made by the AO was that the reliance was placed on statement of so-called entry operator to justify the additions under Section 68 and 69 of the IT Act. These statements were recorded on various dates in some other proceedings not connected with the assessee. Further, the statements were recorded much before the date of survey conducted on the assessee. It was unable to be disputed by the department that the assessee did not have opportunity to challenge such statements, and further, no opportunity to cross-examine the so-called entry operators was given to the assessees. Having heard learned senior standing counsel for the department and having perused the impugned orders of the AO, CIT, and ITAT, the court finds that both the grounds, that is the claim for benefit of Section 1038 of the Act and denial of an opportunity to cross-examine the entry providers, turned on facts. The ITAT was justified in accepting the plea of the assessee that failure to adhere to the principles of natural justice went to the root of the matter. Also, the CBDT circular that permitted the assessee to file revised return if he omitted to make a claim was also not noticed by the AO. In the considered view of the court, the ITAT committed no error in concurring with the view of the CITA and in dismissing the revenues appeal. No substantial question of law arises from the impugned order, and the ITAT's order calls for no interference. Now, this was actually set out in that order, which is why I handed over, Milord. And Milord, there are two decisions of the Madhya Pradesh High Court also. Over here, Milord, paragraphs 11 to 14. 11 to 14. 11 to 14. Per contra, learned counsel for the respondent assessee submitted that under Section 1038, the respondent has lawfully claimed exemption by complying the conditions to avail exemption, which includes shares should be listed on stock exchange. Shares should have been purchased through stock exchange and through banking channel, and security transaction tax has been paid thereon. The shares of Sunrise Asian Limited are listed on Bombay Stock Exchange. Shares have been purchased through demat account, and payments have been received through banking channel, and security transaction tax has been paid by stock exchange, same as in my case. Thus, all the conditions for availing exemption have been fulfilled. It is further contended that under Income Tax Act, there is no provision which requires the assessing officer to investigate the genuineness of shares, because these shares are listed, issued by the company, and records are maintained with the Register of Companies. Thus, these shares cannot be said to be bogus shares as have been issued and subscribed under the Companies Act. The revenue has failed to appreciate that how these shares can be termed as bogus shares when these shares have been issued by the company incorporated under the Companies Act by following the provisions and procedures prescribed under the Companies Act 1956. The issuing company has complied with all the rules and regulations and completed all statutory formalities required for issue of shares. Thus, under such circumstances, these shares cannot be termed as bogus shares. Learned counsel for the respondent further contended that mere sudden increase in share prices on the stock exchange does not ipso facto determine that shares are bogus. If the shares are bogus, then these shares cannot be listed and traded on stock exchange through demat accounts. Therefore, it is incorrect notion of the revenue that these shares are bogus shares. On the contrary, these shares are genuine and lawfully issued by the company by following the law and procedure in this regard. The assessing officer has heavily relied upon the investigation wing of the Income Tax Department, which was conducted in Kolkata in case of some of the companies, including Messrs. Sunrise Asian Limited. This report has never been provided to the respondent at any stage of the proceedings, nor filed by the department before the ITAT or before this court. It is settled law that no material can be used against the assessee without providing the assessee to examine it and, if required, to cross-examine. Thus, there was violation of principles of natural justice that on similar set of facts and in respect of the same share strip of Messrs. Sunrise Asian Limited, the Mumbai bench of ITAT in case of such and such has dealt with identical issues and decided in favor of the assessees. Learned counsel for the respondent has further submitted that as many as 3 high courts, Delhi High Court, Bombay High Court, and Gujarat High Court, also have dealt with similar issues and has dismissed the appeal filed by the revenue. The appellant revenue has preferred SLP against the order of the Gujarat High Court in the case of Principal Commissioner of Income Tax versus Paraspen Kasturchan Pochar, which has been dismissed in limine, upholding the orders of the Gujarat High Court. The apex court in the case of Principal Commissioner of Income Tax versus Srimati Krishna Devi. This is the Delhi High Court decision which I handed over. Decided on 15/1/2021, has held that the High Court has erred by holding that the addition made under Section 68 of the Act by treating impugned long-term capital gains as bogus was unjustified and same was to be deleted. For the aforesaid reasons, we have no hesitation in holding that no question of law, much less any substantial question of law, arises from the order of ITAT requiring consideration by this court.
It is not apex court, it's Delhi High Court.
Delhi High Court.
Yes.
And the last decision is of the Bombay High Court. Just paragraph 4 from this. Paragraph 4. The AO did not accept the respondent's claim of long-term capital gain and added the same in respondent's income under Section 68 of the Act. While allowing the appeal filed by the respondent, the CITA deleted the addition made under Section 68 of the Act. The CITA has observed that the AO himself has stated that SEBI has conducted independent inquiry in the case of the said broker and in the scrip of RFL, through whom the respondent has made the said transaction, and it was conclusively proved that it was the said broker who had inflated the price of the said scrip in RFL. The CITA also did not find anything wrong in respondent doing only one transaction with the said broker in the scrip of RFL. The CITA came to the conclusion that the respondent brought 3,000 shares of RFL on the floor of Kolkata Stock Exchange through registered share broker. In pursuance of purchase of shares, said broker has raised invoice and purchase price was paid by check and the respondent's bank account has been debited. The shares were also transferred into respondent's demat account where it remained for more than 1 year. After a period of 1 year, the shares were sold by the said broker on various dates in the Kolkata Stock Exchange. Pursuant to sale of shares, the said broker had also issued contract notes cum bill for sale, and these contract notes and bill were made available during the course of appellate proceedings. On the sale of shares, respondent effected delivery of shares by way of demat instruction slips and also received payment from Kolkata Stock Exchange. The check received was deposited in respondent's bank account. In view thereof, the CITA found there was no reason to add the capital gains as unexplained cash credit under Section 68 of the Act. The tribunal, while dismissing the appeal filed by the revenue, also observed on facts that these shares were purchased by respondent on the floor of Kolkata Kolkata Stock Exchange and not from the said broker. Deliveries were taken, contract notes were issued, and shares were also sold on the floor of the stock exchange. The ITAT, therefore, in our view, rightly concluded there was no merit in the appeal.
Very good.
My lord, with regard to Naukar, my lord had inquired, I just sent the mail. That order.
So the order of 5th March 25.
Hmm.
You're not able to scroll, huh? What does the order say?
My lord, that my lord allowed them to go to the Vivad Se Vishwas scheme.
Yes. And what is Swati Bajaj citation? You got a copy of that?
Well, I can provide the citation.
You just give citation.
Well, that is 2022 446 ITR 56. 56.
36.
56. 2022 446 ITR 56.
My lord, apart from Swati Bajaj, I'll rely on Sumati Dayal also. My lord, these two judges.
All right, we have heard so and so, judgment reserved. Swati Bajaj.
The way I have kept the file. Don't mess it up. I have specific. Please don't give it to me the way it was. How was it? Did you mess it up? Why did you do it? I did it my way yesterday.
Item number 12.
My lord, this is my appeal. It is a very interesting case.
My lord, may I
learned
just-
friend is
My lord, I
in
have
the
a
point of
demur.
Pardon?
I have a point of demur, my lord. My lord, to the best of my understanding,
what have you
my
done?
lord,
Yeah, I
this
didn't
is
rubbish.
this appeal. The demand is below the threshold limit. Your lordship kindly takes, my lord, the demand, which your lordship will find at page 17. Kindly take page
Just one
17.
moment. Just one moment.
Yes.
Rather from 16. Well, first, there is an order of confiscation and a redemption fine of 81 lakh 61,000. 16, 17. Right.
816.
That.
Yes.
Well, there is a redemption fine of 81 lakh 61,500. Then there is a duty confirmation of rupees 82 lakhs 59,527. So, the duty component is 82 lakhs 59,527, which is below the threshold limit. And there is a circular issued by the board that for the purpose of computing the threshold limit, redemption fine cannot be included. But we have brought the circular, we have brought the judgments. So this is below one, the present. Kindly take my lord this compilation. I will share it with Mr. Kundalia. Josh, you've given. Okay. Well, kindly take for once page 10, first page 10. My lords have got that?
Yes.
Well, kindly take from second paragraph. The matter has been examined. Redemption fine is an option in the hand of the owner of goods to redeem goods confiscated by the department for violation of any provisions of the Customs Act. On the other hand, penalty is imposed on any person who violates the provisions of the Customs Act while importing or exporting the goods out of India. Therefore, the nature and scope of penalty is different from that of the redemption fine. While penalty is in persona, redemption fine is on the goods. However, both redemption fine and penalty are imposed for violations of statutory provisions. Therefore, even though redemption fine cannot be said to be covered under the word penalty, the treatment given to both redemption fine and penalty is required to be identical, and hence redemption fine and penalty would need to be clubbed to decide the applicability of threshold limit if prescribed. So, redemption fine and penalty cannot be included for the purpose of computing the threshold limit. Now, my lord, kindly take the threshold limit circulars. Kindly take first, my lord, page 6 to 7. Page 6. The relevant statutory provision also.
No. Page last paragraph.
I'm sorry.
Accordingly, it is clarified that if imposition of redemption fine alone is a
Then, my lord, it's a different thing.
But here it is not.
Here it is not. Here it is not. Then, my lord, penalty can also be, my lord, that it will be covered.
Club together.
Kindly take, my lord, the instruction. This is pages 6 to 7. The first one.
No, my lord will also see when my lord pointed out the last paragraph.
Yes.
Further, if both the amount of redemption fine and penalty and dispute, and if such redemption fine and penalty is in dispute, taken together exceed the prescribed monetary limit, then the matter should be litigated.
Yes, penalty. But this is not penalty. This is duty plus redemption plus penalty.
If your dispute is only with regard to redemption fine.
My dispute is with regard to
duty, redemption fine and penalty.
Yes, all
but
three.
If there was no duty levied, but only redemption fine and penalty, you can club both together, see the value and then maintain an
redemption fine and penalty.
Yes.
That if.
But if no duty is demanded.
Yes.
Here duty is demanded, my lord. And your lordship will kindly take the circular, the threshold limit.
My lord has considered this in a judgment. My lord has. I'll hand over that judgment, my lord, just now.
And my lord, now.
Sarva Mangalam Gajanan Steel. My lord will kindly see. This aspect has been covered by my lord.
তাতে কি হোল্ড করেছেন জশের?
তোকেও দিচ্ছি।
সর্বমঙ্গলম
দিচ্ছি। And particularly when there's substantial question of law there, my lord. My lord will also see the Allahabad High Court judgment.
But what do you say about what is the question which you have raised?
Question, if my lord kindly goes into the matter now, my lord, for a moment and then decides the aspect of the demurrer question that my friend has come in.
Is that having regard to section 131BA, read with the instructions, revenue cannot prefer this appeal. 131BA imposes a complete bar. This is not a case of recurring nature. This is not a case of violence.
Very interesting fact.
Maybe
very interesting
it may turn out to be an interesting fact in some other
which
matter.
Involves not only the respondents, but also customs officers. All of them.
Kindly then allow me to place the judgments on
this one.
All right, you give a copy.
I've given a copy.
You go
the latest position is that though the circular says the redemption fine is not in the nature of penalty, while considering the provision of the Sabka Viswas SBL DRA scheme, The division bench of Allahabad High Court has held the redemption fine is a kind of penalty at paragraph 31.
That will also help me.
Well, let them take instruction whether they want to proceed with
No,
that.
we want to proceed, seriously proceed in this matter, because this
And this
relates
is,
to
my
an
lord, this is-
aeroplane
Well,
which
these-
comes in as a conveyance, says it's conveyance, and is actually brought in with the intention in violation of the circular, of violation of the notification to be sold here in India. When they find a buyer, they sell it to the buyer.
No, no.
Buyer
sold.
Purchaser files a bill of
It was
entry.
not sold. It was not sold.
Purchaser files the bill of entry, and
No,
then
no, bill of
he
entry was
cancels
never filed.
he cancels the
My
bill
lord,
of entry.
my lord, the case of the evidence,
I have it on record.
they can produce
I
that we
have
have
it on
filed bill of
record.
entry, I will be out of the court.
That bill of entry was filed and it was cancelled by
It was never filed.
by that purchaser, and then upon
By the
payment
buyer
of-
it was filed, my lord. I did not file and it was cancelled.
Essentially, is it not a classification issue?
No.
not a classification issue. It's
Malay, it
pure.
is- Malay,
it's
it is a
pure-
question. Malay, second
allow
point,
me to say,
one minute.
it's a pure case of where there is a violation of the notification of the government. Based on that notification, two things were there. You could bring a flight here into India for 15 days for transit
Right,
purpose. For any operator can bring it to India. Now he had brought this flight into India for a period of 13 days. Thereafter, it took an extension. The notification specifically says the maximum extension that can be given at every stage can't be more than 60 days. So the total, after 60 days, he had to, within 60 days, he had to take back the plane. What he did, in the meantime, he sells these goods to Lakshya, another company. That Lakshya first files the bills of entry and then cancels it, saying that regulations have not been completed by these people. Therefore, I did not buy it. Now, what they do, after giving provisional duty, etc., they take back the flight, and that is when the now question comes in. The customs department is saying that these are goods. These goods were imported. These goods, they could not have imported it without a license from the DGFT, which is clear. Notification is very clear. Under two circumstances they could have done. One was that if they did not have an intention to register this aircraft in India, and second was that they would not be keeping this aircraft after 60 days. Now, my lord, from the records, it is found that Lakshya, that the prospective purchaser, there was an invoice that was there from 2011. This is an incident of 2012. There's an invoice which was dated 2011. Thereafter, Lakshya specifically given a statement, and in fact, in the Panchnama, when the aircraft was seized, it was seen the markings of Lakshya were there inside. The lock of the aircraft was with the Lakshya manager. So in that situation, they are saying that this is conveyance, and we have said that no, this couldn't have been conveyance from the very outset. The notification.
Now you have cleared the aircraft.
Yes, my lord.
They have taken that back long
we have
ago.
paid whatever
Upon a
provisional release
pursuant to a
order.
writ petition here.
Provisional release order was issued. We have taken back the aircraft.
And from the
aircraft was never put to home consumption. It's an admitted fact.
Yes.
My lord, it was used merely as a conveyance.
That is.
And secondly, my lord,
that is what we are saying. It ought to have been a.
My lord, the cancellation of bill of entry by Lakshya was never questioned by the department. That was never questioned by the department.
Show cause notice was thereafter given to this Mahindra, and thereafter Mahindra said no, our group company Gypsaro, which is the actual exporter from there.
So my lord, the Lakshya,
he was the one
which is the prospective buyer. But Lakshya was never given
Right.
to
Then
any show
we'll
cause.
do one thing. We'll admit the appeal, include this question also.
Yes.
Question has to maintainability.
Well, one more point, my lord. If it is a question of dutiability, then my lord, the appeal would lie to Supreme Court.
That also will entertain. Sir, please come. We have
My lord, only one thing. There is a contempt petition that has been filed by them.
That's a different issue.
There is a contempt petition that has been filed by them in this court
for what?
For violation of the order.
Because my lord, we had paid the amount.
High Court.
My lord, the tribunal order was in our favor. So we wanted, my lord, obviously the amount which have been paid has to be refunded to us.
You file a separate application for that.
My lord, we are not pressing the contempt. We are not pressing the contempt, my lord. So far as the, my lord,
We will give
your lordship can record that. Your
No,
lordship.
we will give you liberty to withdraw
Yes.
the contempt application
Yes.
before the single bench.
Right.
And file an application before the tribunal for further direction.
My lord, the tribunal says that tribunal does not have the power to punish for contempt.
Exactly.
That's the difficulty.
Or you do one thing, you file a CAN application here.
Yes.
Very well for that we can do.
And
That we
interestingly,
can do.
they have already taken the drawback of this duty amount.
My lord, my learned friend is very good. My lord, in mix and match.
Not
It's
mix
a
and match.
mixtape. It's a mixtape. I will answer to
Every
the mix-
advantage
My
that
lord,
has been
my lord,
taken.
even if the
I had-
drawback is taken into account, I am entitled to 1.5 crores of amount.
My lord, kindly passes a order of stay of that order so that at
No, that
least-
my lord, kindly, my lord.
So the appeal is admitted on the following substantial questions of law.
Stay হবে না।
A.
আমরা
I
undertaking
dictate,
দেবো যে আমরা এ করবো।
whether the appeal is maintainable at the instance of the department on the ground as to the monetary limit prescribed by the CBEC in circular dated 3/6/2013. B. Whether the appeal at the instance of the revenue is maintainable before this court, and whether a classification issue or the rate of duty arises for consideration in this section. So this will be A and B.
Agarwal. Sandeep.
B2. It is submitted by the learned senior standing counsel for the appellant that a contempt application has been filed by the appellant before the learned single bench on the ground that the amount which was deposited before the department pursuant to
It was encashed. It was encashed. The bank guarantee was encashed.
bank guarantees.
Bank guarantee
Where
was
is
in
the order passed in the writ petition?
when the order passed in writ petition right now, my
WP
lord.
20 of 2020.
My lord, we'll get that. Kindly give me 1 minute, my lord.
Bank guarantees was in cash and is kept in fixed deposits.
Bank guarantee was encashed pursuant to a direction given by the tribunal.
Yes.
The amount has been, my lord,
In fixed deposits.
has to be kept in a fixed
We'll
deposit.
see what is
My lord, we have to give, my lord. Kindly give me 1 second.
here. Page 4.
My lord, kindly take this one. Page 4. It is there at page 4. No, ye alag hai na. Page 4. Your lordship will find the order at page 4.
Page 4. No, I can't.
I filed a contempt application before the learned single bench of this court, alleging single bench of this court in CPAN.
Only in CPAN, I am giving your lordship the number. They do
Number so and so.
ওদের কাছেও তো থাকবে।
Alleging disobedience of the order and direction issued in WP number 20 of 2014.
Well, this is CC. Well, this is the original side. CC 84 of 25.
84 of 2025. Alleging violation of the order dated 21st January 2014 in WP number 20 of 2014. The copy of the said order was placed before us for consideration. While disposing of the writ petition, the learned single bench observed that the customs authorities have already invoked the bank guarantee and they are directed to keep the said amount separately in a fixed deposit carrying interest.
My lord, may I?
With any, yes. with any nationalized bank until further orders that may be passed by the SESTAT, either on an application for stay or in an appeal itself. The learned tribunal has disposed of the appeal by order dated 3/11/2023, which is impugned in this appeal.
Yes, sir.
In the penultimate paragraph of the impugned order, the learned tribunal has directed release of the amounts in possession of the department maintained by way of an interest earning fixed deposit in terms of the orders passed in WP number 20 of 2014. As could be seen from the direction issued in the said writ petition, the amount was the bank guarantee which was already encashed, and the amount which was realized was directed to be kept separately in a fixed deposit carrying interest with any nationalized bank until further orders that may be passed by SESTAT, either in the stay application or in the appeal. Thus, there was no positive direction issued by the learned writ court that upon the respondent hearing succeeding in the appeal before the tribunal, they'd be entitled to return of the amount. Therefore, we are of the view that the contempt application in CC number so-and-so is not maintainable. Faced with this situation, the learned advocate appearing for the respondent submits that they will withdraw the contempt application. And until the same is done, all further proceedings in the contempt application shall remain stay. Liberty is granted to the respondent to file appropriate application for appropriate relief in this appeal, which will be considered along with the appeal. This you are going to file?
Yes.
Now? You are going to file this one?
My lords, I'm not carrying appropriate copies. Maybe on
Then
the
you
text.
at the time you
Yes, yes,
admit the appeal, then you shall order.
My lord is making passing an order of admission with liberty. With yes.
This
Grateful,
this you return to Rahul.
All the others. Lords, when my lord is keeping this matter, my lords, has
It will come
indicated any date?
2026.
Oh, much.
2026.
2026.
Nothing will happen.
Much obliged. We don't really want to cause much grief to my lord next few days.
Item number 13.
But sometimes matters happen such kunta. Amari to matter.
No, sir, এটাতে আপনি নেই, sir.
Yes.
It may please your lordship, my lord. The matter already came before your lordship for the consideration earlier occasion. May I remember the facts? What is the facts was, my lord? I am the manufacturer of the wagon, my lord, and wagon. And generally we sold it to the government of India, but in this case we have sold to the private party. But what happened, my lord, in the month of December 2014, we have raised the invoice along with the central excise duty of 60 lakhs. We have deposited it, but we have wrongly raised the invoice because the agreement with my client was per wagon was 1.80 crores, but it is raised as per the 1.17 crores per wagon. So when they have identified, they have not accepted, then again I have cleared. In the meantime, I again raised the invoice on 28 January 2015, and I paid again the 65 lakhs on account of the central excise duty. Against the same transaction, I paid twice, my lord. And I have taken the handback credit suo moto, but during the course of audit, it has been identified, and I reversed by my own, and before issuing the show cause. They have issued the show cause notice, but in the show cause, they have labeled the allegation in respect of the suppression of the facts for the imposing of that penalty. But it is a very cryptic one. It is only a sweeping statement. Now, against that there is certain law that if I pay the duty before the issuance of show cause, the penalty should not be leviable. Against this show cause, I have given my reply, extensive reply. I have taken the extended period of limitation also. The suppression facts I also taken.
One second, one second. I think it is the wrong side.
It is edible oil.
This is Emami Agrotech.
Umami
No, Titagar wagons. It's a Titagar wagons.
It is regarding refining.
Titagar rail systems. What is that? I am trying to find out. That is, he said wagon, this is oil.
70.
Emami Agrotech must be item 6 or 7. This is Sexa 17 of 2025.
One caster has.
ওটা কাজটা চলে গেছে ফাইল নিয়ে গেলে
Well, it has to be taken up tomorrow. File may have. Tomorrow, Malat. Tomorrow. No, file.
Let us see, file is not here.
No, Malat. Malat,
Probably it would have gone along with item 6 and 7.
No, because item 6 and 7 is now there. Umami Agrotech
This
is
Emami Agrotech should be going along with 6 and 7 on 28th of August. All right, tomorrow.
Yep, tomorrow.
Day after tomorrow. No, Monday.
Monday.
Monday. That file is not there. Monday. Next.
Right, cool.
এই তো আছে ওটা
না নেই বলছে
অঞ্জন দা আছে
All right, we can't finish 10 minutes.
Yes, Malat.
Monday. Anjan, Monday we'll have.
ওটা কোথাও চলে গেছে
And who's appearing in item 14?
my lord, we are appearing, my lord. 14, 15,
14, 15, 16.
16.
Actually, 14 and 15, Mr. Chakraborty is leading me. I'm seeking for an accommodation for
আমাদের
today.
file করেছে
He's
ওটা
indisposed.
He's
My lord.
indisposed.
No, that's okay. My lord takes it up on Tuesday then.
Tuesday.
Only one thing, in this also there is a contempt that has been filed
তেলেঙ্গানা
in Telangana. Courts are here,
But we can't stay those.
I know. They have gone to Supreme Court against that order. Against that order, they have already filed a
What is this gold? Is it?
gold, my lord. And not a very, again, today I'm dealing with interesting matters. This gold is father and son duo. They get this gold from the canalizing agencies, one of these. And then they
diverse
with conspiracy, I would say, with other officers, etc., they get a permission to export this gold by hand baggage,
manual shipping
manual shipping bill, which was actually not allowed by the commissioner, which has come to light in the investigation later on. Now he goes into the airport, the son, Preet Agarwal, which is the second matter. He goes inside the court. He goes inside the airport with the gold, with the officer. He goes into the SDO office, which is past the immigration. Doesn't do his immigration. He goes with this person inside that SDO. He gets the gold from there, comes out with the gold
from the security
from the outside the security fold. He comes and hands this gold over to his father, who was outside. Says that my
luggage
luggage is 54 kgs and Emirates only allows 7 kg. So he returns. This is his version. He returns this gold to his father. Now father takes this gold to Hyderabad. Was taking this gold to Hyderabad in the name of the son. The air ticket is in the name of this son. He's going, and then the son is traveling back to the going inside the through via immigration to Dubai. Now this act was caught by Customs Department, and it was also there are other show cause notices also pending in this, and this had been going on for a long time, and it was a racket.
All right, we'll have it on 30th.
On
Very well.
30th.
30th.
Wednesday, next Wednesday.
Next Wednesday. That's fine. My lord. I'm grateful, my lord.
Item 14, 15, 16.
Item number
The
14.
request of the learned advocate for the respondent.
Again, here also their plea will be the
monetary limit.
Monetary limit.
না রিটার্ন যাবে 16 crores হচ্ছে এখানে।
But here I have a even better answer because the whole
Gold
gold is
16
value
crores.
is 16 plus
Crores.
crore. So we are
In the
saying
meantime, you find out whether any appeal has been filed against the Meghalaya judgment.
Meghalaya,
Meghalaya
yes.
High Court, Chief Justice I.P. Mukherjee's judgment.
Yeah.
He says in the case of smuggling, the intent of the notification is not to cover cases of smuggling. Monetary limit will not apply.
I'll find.
You find out whether assessee has gone on appeal.
I'll do that. Grateful.
Next,
Item number
17.
কত ছিল আমাদের
17.
14 15 16 17 or
17 is different.
14, 15,
16 17
17.
17 is also same.
17 is against the officer,
various persons
against the officers who were involved,
return চলে
Who
এসেছে।
accompanied him.
and that has been held as procedural.
Procedural lapse.
Procedural lapse of the officers. In fact, the officers were supposed to hand the gold to take him, escort him till the aircraft. They didn't do that. They left him, and they.
All right.
And one of the officers says he didn't understand that the commissioner had he misinterpreted and understand the commissioner had said no to manual ships.
স্যার এইটা কিন্তু
Mile.
17টা রিটার্ন চলে এসেছে সব কোটায় রিটার্ন চলে এসেছে ফ্রি সার্ভিসিং কথা
2 to 30 will come. A couple of visitors are coming.
Not only on bill prayer, my tomorrow one matter is returnable. Instead, I am giving the number to the code officer. Instead of tomorrow, that will be on Monday.
Sir, I have some requests. Sir, this court had assigned my case.
Okay.
It's already been assigned. You appear before.
Sir, the
You are
case.
not behaving yourself properly, madam, before the
Sir,
court.
sir, the
You have to
court
make
is
submissions to the court and leave the-
everything, sir, written verbal both ways, sir.
No.
The court is not intending to do anything for my
I
case,
have
sir.
already assigned it to another bench, and that bench will hear. I think the learned judge is not.
Yes, sir, Justice Vishwarup Chaudhary, sir. Sir, to the court of Justice Vishwarup Chaudhary. Sir,
He is not well today, therefore he is not present. He will join. As soon as he
Sir,
comes.
I have submitted my request both verbal and
You can
written manner, sir.
No.
Sir, he is not listening to my any of the requests, sir.
No.
Please help me, sir.
I have already assigned the matter to a particular
Sir,
judge.
I have already submitted a written complaint to the relevant email ID, sir. So please consider my request. I have written everything in detail, sir. It's a request, sir.
Yeah, I'll consider.
But sir, he is not doing anything.
My lords, I am not able to hear anything. Nothing is audible. No, I think the court side is not audible. No, I can't hear anything. My lord, I can't hear anything. सुन रहे हैं?
Nothing in here. Nothing. I am also not hearing.
Nothing is audible.
सर मेरा लैपटॉप से बोल के देखिए, मैं सुन रहा है। मेरे लैपटॉप में से सुन रहा है, आवाज आ रहा है। हाँ,
कोर्ट का सुन रहा है कोई? My request is that my lordship can assign any date. My lord, I am not able to hear what your lordship is saying, but your lordship can assign any date. My junior is there, my lord.
My lord, we can't. We are unable to hear your lordship, my lord. We are unable to hear your lordship, my lord. We are unable to hear your lordship, my lord. Hey, तपन के फोन टा दे तो भाई, तपन
The reason second time said that I have already decided that you cannot decide it, revisit the same issue.
Lordship, on the first occasion, there was a circular of the tribunal which said that, which permitted the clerks of the advocates to file this application. Under that impression, my clerk
Such a big assessment, how a clerk can file.
Lordship, that
Please
was a
show the revisional board's order.
Lordship, this is against penalty order, Lordship. The order of imposition of penalty is in a supplementary affidavit, Lordship, because at the time when I applied for release, at that time penalty order had not been issued. It is at page of my supplementary affidavit. It is at page 7, Lordship, and a typed copy is at page 15, Lordship. I have attached a typed copy also.
Supplementary affidavit.
It's at page 15. আপনাকে তিনটে দিয়েছি. Lordships will find.
I think page 15 also.
Page 7 is the handwritten copy, and page 15 of the supplementary affidavit is the order sheet.
This one.
Lordship, please. Lordship, please.
Yes.
Lordship, a consignment of cement arrived at a railway station in Dalkola. Lordships are very well aware that as per Rule 100A, the railways also were supposed to insist on a waybill before giving delivery of the goods. That they have not done. It was a Sunday, Lordship, 5th May 2013, when the goods arrived. My office was closed, so waybill could not be generated. On 6th, I tried to generate a waybill, but there were some system errors, system glitches, because of which waybill could not be generated. I have enclosed copy of my screenshot in my original application at page 24, our screenshot which shows that there was some technical problem which I encountered while generating a waybill. Lordship, I cleared the rake and brought the goods to my declared godown. It is not that I was trying to avoid any taxes, and I did not take it to an undisclosed location. I have taken it to my godown, and on the godown, the consignment moved through 89 trucks, Lordship. The full load moved through 89 trucks to my godown. All the goods came into my godown, Lordship. And on 7th May 2013, the respondents came to my godown. They found that the entire stock was there. The entire stock was found intact there. I did there at that point of time when they came. I was my C&F agent. He was able to contact my office in Kolkata, and they immediately generated the waybill. Within 2 hours of their reaching my godown, the waybill was generated and was submitted before them, Lordship. There is no finding of the respondents that there was any attempt on my part to evade the payment of taxes, Lordship. There is no allegation of contravention of Section 73, Lordships. Besides, Lordship, any attempt at evasion from my side would have been self-defeating, because this was a stock transfer from my Bokaro factory to the Dalkola dump. Because for stock transfer, Lordship, I was duty bound to issue an F form to my factory. Otherwise, they would have been charged to central sales tax. So since since I was mandatorily required to issue an F form, Lordship, I had to declare it in my returns. So there was no scope for me to evade any taxes, Lordship. If I evaded taxes, my
the e-way bill was generated on 6th of May.
7th, Lordship. On 7th.
We visited
After the respondents reached my office, Lordship.
But is there an intention to evade?
Yes, Lordship. That has not been. There is no allegation towards that.
I'll leave it to you, Lordships.
There is no allegation towards that.
It cannot be believed a company, man. It's not a one person. Dalma is a big company. One person, there was a technical glitches. They do not do it for 2 consecutive days. Well, they get the goods. Well, we do not know what.
No, they took it for granted.
Lordship, I tried, Lordship.
There's
a screenshot.
Officers did not visit the place, they could not, possibly they would not have generated the UAV.
That is a standard argument which they take, Lordship. I have attached a screenshot of my attempt to generate a waybill, Lordship. That is at page 24 of my.
What date?
Lordship, the date is not visible, Lordship, on the screenshot, but my client tells me that it was done on, they tried on 6th, because 5th was a holiday.
Because you are listed companies, big corporate houses, you won't respect the taxing authority.
Lordship, I am a joint venture company of Steel Authority of India Limited. I regularly take waybills, Lordship. Every month there is movement. I regularly take waybills. So there was no reason. Lordship.
What you need to consider is, it is a case of stock transfer. Interstate stock transfer.
Lordship.
From which state to which state?
Jharkhand, Bokaro, Jharkhand to West Bengal.
West Bengal.
My plant was located at Bokaro. From their movement, if I had not disclosed this in my returns, I would not have been able to generate F forms. F forms were generated manually at that point of time. I would not have been able to issue it to my factory, and they would have been charged to central sales tax.
Here seizure was effected.
Lordship, yes. Seizure of the goods. Seizure was effected, and goods. I was allowed to keep the goods in my godown itself. Then after I approached the tribunal, I had to deposit a security of rupees 13 lakhs, and on that strength of that, goods were released, Lordship.
And penalty imposed is
45 lakhs, Lordship. 45 lakhs.
That 13 lakhs was 5% of the fair market value.
Lordship, the goods are valued at about 1 crore 30 lakhs, approximately 10% of that, Lordship. Approximately 10% of that.
And where is your reply to the show cause notice? Initially,
reply to the show cause notice, Lordship?
Not there.
That is not
right.
there.
Where is the original authority's order?
Original authorities order, the first penalty order. Lordship, the penalty order I just pointed out to Lordship,
That's the
it's
only-
15. That is the order of imposition of penalty.
Against which you filed before the
Against which I had already applied before the taxation tribunal for release of goods, paying for release of goods. Subsequently, they have imposed penalty. The penalty order I have enclosed in my supplementary affidavit.
But is mens rea are required to be considered?
Lordship, to my mind, no, because Lordship, section 76(2) incorporates the reason to believe on their part. They have to establish that there is an attempt on my part to contravention of evasion, and there's an attempt on my part to evade taxes, Lordship. There are several judgments of this Honorable High Court, Lordship, where where Lordships have consistently held that there is an onus on the respondents to also establish that there's an attempt on the part of the petitioner to evade payment of taxes. Lordship, in my case, I have not taken the goods to any undisclosed location. It is not that they have been, I've sold them right from the railway station, or it with any truck of mine was intercepted on the way, Lordship. I have taken it to my registered godown, Lordship. I have put an index also, Lordship, on the top.
First judgment, which is the paragraph number?
Lordship, Hindustan Steels Limited. I perhaps have not attached copy. Lordship, the Zargamuddin Ansari at page 138, Lordship. Judgment of this Honorable Court, page 138, Lordship. Kindly allow me to read from paragraph 35, Lordship.
Once again, where is it?
Zargamuddin Ansari, Lordship. Judgment, the judgment number 2, Lordship, of my index at page 138 of that, Lordship.
Once again,
Zargamuddin Ansari Anwar versus Commercial Tax Officer and others.
Page paragraph number?
Paragraph number 35 on page 138, Lordship. Kindly allow me to read from paragraph 35. It was incumbent on its part to consider the documents subsequently produced by the petitioner and to come to a finding as to whether the petitioner had evaded payment of sales tax or had intended to do so for the purpose of imposition of penalty. The decision of the Honorable Supreme Court in the case of Hindustan Steel Limited and the observations made therein makes it clear that whether penalty should be imposed is within the discretion of the authority, but such discretion is to be exercised judicially and on a consideration of all the relevant circumstances, and penalty should not be imposed merely because it was lawful to do so, Lordship. Then, Lordship, the second judgment is of this Honorable Court, Kodak India Limited, at page 139, Lordship.
You give the paragraph number.
Lordship, it is at page paragraph 21, Lordship. The word may in the relevant provision indicates that there is scope for exercise of discretion, but it is judicial discretion. Section 77 of the VAT Act also incorporates the expression may, Lordship. Then, Lordship, Ferring Pharmaceuticals Limited, paragraph 25 at page 245, Lordship. The words reason to believe frequently occur in various fiscal statutes. These words operate as a safeguard against an arbitrary exercise of power by the authorities under fiscal statutes, which empower such authorities to exercise sweeping and drastic powers. Section 76 of the 76 subsection 2 also incorporates the expression reason to believe, Lordship. There is no allegation of any contravention or any attempt at contravention or any attempt at evasion of tax in the order of imposition of penalty, Lordship. They have mechanically proceeded to impose penalty, Lordship, without any finding as to whether there was any possibility or not. The fact that forms had to be issued in this case, and for which I was duty bound to declare this stock transfer in my returns, without which I would not have been able to generate the forms. And if I did not generate the forms and did not give it to my counterpart in Jharkhand, they would suffer taxation.
What do you say?
But the report, we have filed our opposition to it. In our report, that there's a report, at page 4. And the page is in the opposition, it is part of the documents my learned friend has relied upon. It's an opposition filed before the tribunal, my lord. There's a report, my lord. At the time, my lord.
Page number?
That it is part of the opposition. My pagination is 4. I do not know one.
Lordship, it is page 2 of the affidavit in opposition, Lordship, submitted by the respondents. Report.
Report. You have annexed it.
It is been annexed by you only.
And this was a report filed at the time of seizing the goods. May I find this? That's it for something that is so. দর্শককে দিয়েছিলেন তো অপোজিশনটা It's a part of my opposition. It is part of my opposition.
But the fact remains, it of course that 50 form 50 50A not
not complied
with, it was not produced, endorsement was not there, and they are required to do that before the goods are shifted from the railway station. But the fact is that when you went to the godown on 7th of May, all 52,959 bags were intact.
No, that is a fact, but this is also a fact.
But the conduct, the problem is the conduct of the SSC. I mean,
Lordship, but
with corporate houses, if you take things for granted.
Lordship, Lordship, they have ultimately generated the waiver, Lordship, and
Let it be restored and go back to the author before the tribunal. Well, let this be issued. My lord wants to decide this.
Tribunal, if it goes,
it will take 5, 6 years.
they will not be able to do
But my lord, if my lord, this corporate houses takes a excuse of my lord, glitches, technical glitches, it is a difficult.
That is all unbelievable.
I have enclosed
That is
the
all
screenshot also,
afterthought,
Lordship.
unbelievable
This is
story.
my landed senior friend's idea.
Exactly.
Lordship, I have enclosed the screenshot also, Lordship. And Lordship, when a dealer, I ask this question to myself, when a dealer is regularly taking waybills for all his consignments,
So
what could be the reason?
You took things for
There
granted.
is a possibility of human error always, Lordship. In whatever be the size of a corporate, Lordship, be it a one-man show or a 500-man
What we
corporate,
can do is,
Lordship,
whatever you have paid before
Lordship,
the tribunal for release of the,
Lordship,
that will be forfeited towards penalty. Instead of
Justice-
45 lakhs,
Justice
you
Chair.
go away with 13 lakhs.
Lordship, that also was on the higher side, Lordship. I'll leave it to
No, the
Lordship.
discretion can be exercised. It can be reduced to 5% or 25,000 rupees, whichever is less.
Lordship.
In terms of the proviso.
77.
Below the table. But for which the commissioner should be satisfied that the contravention is on account of a clerical error.
Lordship. Lordship. That rider is there to that proviso, Lordship. I will only put forward before your lordship my argument that there is no attempt and no possibility also. Not only
He will
attempt,
reduce it to
no
5%. And he'll apply for refund. You reject the refund application. Another 10 years, it will keep on going. Please come, let us see as we dictate what happens is. This writ petition has been filed challenging the order passed by the West Bengal Taxation Tribunal, dismissing the application filed by the petitioner. Where is the order, sir? Order passed by the Taxation Tribunal dated 4th of March 2025, correct? In an application filed in RN 930 of 2013. The petitioner filed the said application before the learned tribunal, seeking condonation of delay of 440 days in filing the application, being Can 51 of 2025, which was an application filed for recalling the order dated December 1, 2023, by which the main application, being RN 930 of 2013, was dismissed for default. The learned tribunal was not inclined to exercise any discretion in favor of the petitioner on account of their conduct. Firstly, the earlier application was filed with an affidavit supported by an affidavit sworn to by the advocate clerk, which the learned tribunal did not accept, which the learned tribunal rightly did not accept. The second application was filed with a delay, seeking condonation of delay of 440 days in filing the application. Certain reasons were given by the petitioner which did not find favor with the learned tribunal. Consequently, the application stood dismissed. Agreed by the same, the petitioner has preferred this writ petition. We have elaborately heard so and so. There can be no second opinion as regards the correctness of the order passed by the learned tribunal, because if the facts and circumstances which were placed before the learned tribunal was placed before this court, in all probabilities this court would also have taken the same, arrived at the same conclusion as that of the tribunal. But one issue which persuades us to go into the merits of the matter is that the petitioner will be left remediless and they will be compelled to pay the entire penalty of rupees 45,01,260, calculated at the rate of 14.5% on the total value of 52,956 bags of cement. Therefore, we are inclined to consider the correctness of the order passed by the Joint Commissioner, Commercial Taxes, Raiganj Range, dated 6/7/2013, by which penalty was imposed. It is made clear that this order shall not be treated as a precedent, and it is passed considering the peculiar facts and circumstances of the case. The facts which are not in dispute are that the cement was manufactured in the state of Jharkhand and stock transfer was effected to the godown of the petitioner, the godown of the manufacturer in the state of West Bengal. For which purpose the petitioner had generated Form F declaration.
Subsequently, for subsequently.
Which was for which transaction the petitioners subsequently generated Form F declaration, which satisfies the requisite condition for stock transfer, failing which the goods were liable for payment of central sales tax. The respondent revenue cannot dispute this fact. Secondly, the reason for imposition of penalty that too at 14.5%, is on the ground that waybill was not generated in form 50 capital A, and the goods were shifted from the railway station to the godown of the petitioner. And this came to light only when the officers of the department inspected the godown on 7/5/2030. The consignment, which was dispatched from Jharkhand on 2/5/2013, arrived at which railway station?
Dalkola.
Huh?
Dalkola.
Dalunka railway station on 5/5/2030. It is an admitted fact that on the said date, no waybill was generated in form 50 capital A. On information being received that a huge stock of cement were being shifted from the railway wagon, the officers of the respondent department inspected the godown on 7/5/2030. On the very same day, the petitioner had generated the waybill, and it was placed before the authority. Thus, it is clear that on the date the cement bags were moved to the godown from the railway station, there was no valid waybill. This would undoubtedly be a statutory violation. But while imposing penalty, what is required to be seen is whether there was an intention on the part of the petitioner, who is a registered taxpayer, registered dealer, to evade payment of tax. The Honorable No. One second, sir. Honorable Supreme Court in Hindustan Steel Limited versus State of Orissa, 1970 within bracket 25, sales tax cases 211, observed that the liability to pay penalty does not arise merely upon proof of default in registering as a dealer, full stop. An order imposing penalty for failure to carry out the statutory obligation is the result of quasi-criminal proceedings, and penalty could not ordinarily be imposed unless the party concerned either acted deliberately in defiance of law or was guilty of conduct which was contumacious or dishonest, or that the dealer in question had acted in conscious disregard of his obligation. It was further observed that penalty could not also be imposed merely because it is lawful to do so. Further, whether penalty should be imposed for failure to perform a statutory obligation was a matter of discretion of the authority to be exercised judicially and on a consideration of all the relevant circumstances. This decision of the Honorable Supreme Court was relied on by the Honorable Division Bench of this court in the case of Zargasa Ansari versus within bracket Anwar versus Commercial Tax Officer, 2001. (2001) 38 STA. STC it should be. STA. 129 within bracket Calcutta. HC. May, that was May. Yeah, May. In Kodak India Limited versus Deputy Commissioner Commercial Taxes, Midnapur Circle, 2003 41 STA 132 within bracket Calcutta High Court. The Honorable Division Bench of this court was considering a case of imposition of penalty upon seizure of the consignment due to non-production of permit. Wherein the court took into consideration the decision of the Honorable Supreme Court in Hindustan Steel Limited and observed which paragraph he read? No, this Kodak. This Kodak judgment, which paragraph you showed?
Lordship, on page 139, paragraph 22, Lordship. Paragraph 21, Lordship. Paragraph 21. The word may in the relevant penal provision indicates that there is scope for exercise of discretion, but it is judicial discretion.
Paragraph is not
And the reliance on Hindustan Steel, Lordship, is in paragraph 13, Lordship, 1-3. Paragraph 12, Zargamuddin Ansari is referred to, and in paragraph 13, Hindustan Steel is referred to, Lordship.
In so Kodak, the Honorable Supreme Court, the Honorable Division Bench of this court followed the decision in Hindustan Steel Limited and Zargamuddin Ansari within bracket Supra. In Ferring Pharmaceutical Private Limited was the Assistant Commercial Tax Officer. 2006 47 STA 236 within bracket Calcutta High Court. The Honorable Division Bench was considered the correctness of the order passed by the tribunal, which affirmed the imposition of penalty on the dealer. It was pointed out that since there was no attempt on the part of the petitioner therein to evade payment of taxes, and as there was a bona fide mistake, penalty cannot be sustained and was set aside. And direction was issued to refund the penalty realized from the petitioner therein. In the case on hand, the respondent has nowhere stated that there has been an intention on the part of the writ petitioner to evade payment of tax. It is no doubt true that there was an statutory obligation on the part of the petitioner to generate the payable, which they had done only on 7/5/2013, which ought to have been done on 5/5/2013, before the goods were dispatched to the godown from the railway rake point. Certain reasons have been given, assigned by the petitioner for not being able to do so, including glitches in the system, etc., which has not been established beyond reasonable doubt. Nonetheless, the fact that the goods were not an interstate sale, but an interstate stock transfer from the place of from the manufacturing unit of the petitioner to the godown of the petitioner in the state of West Bengal, which stood established on production of Form F declaration. Therefore, the non-generation, that apart, going by the past business activities of the petitioner, there has been continuous movement of such cement bags from the place of manufacture, which is situated in the state of Jharkhand, to the state of West Bengal on stock transfer. And there appears to have been no antecedents on the part of the petitioner to evade payment of tax. Therefore, we are convinced to state that the non-generation of the waybill can be construed to be a clerical error, for which there is discretion vested with the commissioner to impose lesser penalty than the penalty provided in the table under subsection 1 of section 77. Full stop. Therefore, we are of the view that the petitioner should have exercised more caution and care, especially when the petitioner is a very large business house and has been carrying on such activities for a prolonged period of time. There has been some carelessness and clerical mistake on their part, and therefore penalty has to be imposed, but not at the rate of 14.5% imposed by the authority. Accordingly, the writ petition is allowed, order passed by the learned tribunal is set aside, and the order passed by the authority imposing penalty at 14.5% is modified, and the penalty is reduced to 5% of the fair market value of the seized goods on the date of seizure. The petitioner has deposited a sum of rupees
13 lakhs.
Rupees 13 lakhs for the purpose of release of the goods which were released pursuant to direction issued by the learned tribunal. Full stop. The respondent authority is first respondent authority is directed to calculate the fair market value of the cement bags on the date of seizure, arrive at the penalty at 5%, deduct the said amount from and out of the deposited amount of rupees 13 lakhs and refund the balance to the petitioner. The entire exercise shall be completed within a period of 3 months from the date of receipt of the server copy of this order. In respect of the amount which has been directed to be refunded after deduction of the 5% penalty shall not carry any interest.
I'm grateful.
Yes. Yeah.
PL number 3.
Please, your lords.
Yes, he was waiting.
Earlier occasion, my
My lord, I am for the respondent in this matter, my lord.
Mr. Bhattacharya is not very
Upon Vanjo is appearing.
Upon Vanjo not Where is Juma sir? It is other division which you only heard the matter. I have got notes. She wanted to strike down other act. What is he saying? What is your senior saying?
My lord, in this, my lord, the circular. If your lordship consider the circular, my lord, 5.3.5, what my landlord friend is asking, my lord, that without giving him reasonable opportunity of hearing, the verification report has been submitted by the CGST authority. That is his all cases here, my lord. And when the court below, if your lordship takes up the order impugned, against which my landed friend, my lord, preferred this appeal, if your lordship kindly have a look to the order impugned, my lord, kindly come to my lord page, my lord.
250.
No, we are taking from the memo of appeal. Sir, their writ petition was dismissed on the ground of alternate remedy.
Yes, my lord, my learned friend specifically made a prayer before the trial court that he wants to have an appeal against the order. That is the, my lord, for, if your lord kindly consider the order impugned, my lord, at page, my lord, kindly sees, my lord, what my learned friend stated before the court
This is
below.
the fresh copy, my lord. You must ask.
Kindly come to my lord, order, paragraph 4, my lord. Paragraph 4 of the order, my lord.
What is this judgment? Huh?
No, my lord. This is the impugned order. There is some illegible copy which I have annexed. That is why the fresh copy I asked from the client and.
My lord, kindly see paragraph 4, my lord. After the apportionment order has been
No, Tapan Bhaji is appearing through a laptop or
Laptop. This is the problem. He is referring para 4 of the impugned order passed by the learned single judge, my lord.
that we know what he has done. Why can't you file appeal?
My lord, there is an explanation. Because of that, I have suffered 31.80 crores. And that is why there is a huge erosion in my surplus and reserve and surplus, my lord. Ultimately, in the 2024, for the first time, we have received some amount, my lord, from the under the direction of the Kerala High Court, under the arbitral proceedings. After that, we have decided to do something against the deadlock project. What is the project, my lord? I am telling you, my lord. In the state of West Bengal, in the Bidhannagar municipality, state of West Bengal decided to launch a project, that is Amar Shahar project, to provide the e-facility to the citizen of.
Oh, this was that verification report.
Yes, my lord.
Without notice.
Yes, without notice, without any show cause.
The order is of the state, but we had relied upon the central's report.
And that central report was not put to them.
Yes, had fallen from my lord that whether any show cause was given or not. So that's why my lord wanted to hear.
Oh, you please show which is the relevant paragraph in this order.
Well, that impugned order. My lord, also kindly take page 250 and last paragraph. Subsequently, the Central Tax Authority, last paragraph, has been verified the report dated so and so by email dated 22nd of February 2023 along with annexure 2.
All right, two questions. Whether the central authority before preparing the verification report, did he put the assessee on notice?
No.
It is an adverse report.
May I submit what will kindly for my senior? The thing is that, my lord, everything has been done under a guidelines formulated subsequent to the order passed by the Honorable Supreme Court. If your lordship kindly see the guidelines, if your lordship kindly see, page number 267, para 5.3.5. Now, if your lordship, may I read, my lord? In respect of verification done by the counterpart officer, this means the authority is the state tax officer. They before them they file their claim of the transitional credit. Now, if there any central part is there, then they have to send to the counterpart, means the central authority. After verification, he will prepare a verification report in the form detailed in Annexure 2 of this circular, specifying the amount of transitional credit which may be allowed to be credited to the electronic credit ledger of the applicant and the amount which is liable for rejection, along with detailed reasons ground on which the said amount is liable to be rejected. Such duly signed verification report shall be sent to the counterpart officer to the jurisdictional tax officer at the earliest, though generally not later than 10 days from the date of receipt of the request from the jurisdictional officer. In case where the adjudication or appeal proceeding in respect of Tran 1, Tran 2 related matter are pending or concluded against the applicant, the counterpart officer shall categorically bring out the relevant facts in his or her verification report along with detailed findings, admissibility, inadmissibility, reason of inadmissibility thereof, and copy of the relevant notice and orders. Thereafter, my lord, for the purpose of verification of the claim, the transitional credit, the jurisdictional tax as well as the counterpart tax officer, if required, may call for relevant records, including requisite document, written invoices, as the case may be, from the applicant. Now, if your lordship kindly see para 3.5.3.7, after receiving the verification report from the counterpart officer, the jurisdictional tax officer shall decide upon the admissibility of the credit claimed by the applicant. In case the jurisdictional tax officer finds that the transitional credit claimed by the applicant is partly or wholly inadmissible as per the provisions of the Act and the rules thereof, then a notice shall be issued by the jurisdictional tax officer, which has been issued to the petitioner by the state tax officer, to the applicant, preferably within a period of 7 days from the receipt of the report from the counterpart officer, seeking explanation of the applicant as to why the said credit claimed by him should not be denied wholly or partly, as the case may be. The applicant shall also be provided an opportunity of personal hearing by the jurisdictional tax officer, which has been provided by the state tax officer, my lord. If required, the jurisdictional tax officer may seek comments of the counterpart officer on the submission made by the applicant so far as the said submission relates to the tax, which is state tax officer short from the central. They have also given the same finding that whatever we have given in our verification report, this is the correct report. Now, based on this, my lord, everything has been decided by the state authority. Now, there is the guidelines, my lord, where there is no provision, there is nothing has been indicated that central tax officer would have to give an opportunity of hearing to the appellant, my lord.
Circular does not.
Does not.
But principles of natural justice requires. See, if you come to
My
the
lord,
state
my
tax
lord, that up, your lordship kindly sees, my lord, why my landed friend waited for a year together. There is no explanation why he has not come to the court, my lord. My lord, he is blowing hot and cold at the same time before the trial court, saying that he wants to prepare appeal, and now prefer the appeal here before lordship, saying that no hearing opportunity has been given to him. My lord, circular does not provide him. Your lordship is thinking.
Sorry for interruption. Please. See, he followed the procedure. State authority followed the procedure. But he was so afraid of your authority. If you come to second page of the impugned order.
Yes, my lord.
251.
251, my lord.
As the learned central last paragraph.
Yes, my lord.
Central jurisdiction authority is the competent authority for verification of the claim of the SENBAT, and the undersigned sought a report from the so-and-so drawn upon due consideration of the objections of the instant registered taxpayer, response so-and-so, email so-and-so, he upholds the objection. So therefore the undersigned. So this opportunity after the verification report gives them the discretion whether wholly or partly it is inadmissible.
Now, what they have done, my lord, as per their VAT, they have sanctioned it. They have also credited. Now, with regard to the SENVAT credit, that has been denied pursuant to the report of the central tax officer. Now, if your lordship kindly see page number 267, 5.3.8, my lord.
Sir, follow-up notice was issued on 20th of February.
Yes, my lord.
Asking him to raise objection.
Yes, my lord.
He's raised 7 objections. Nothing has been dealt with by the state authority.
That can be the issue that state has not dealt with. But with regard to the verification done by the central authority, no opportunity has been given. There is no such guidelines.
Correct. So therefore, we will say that the state authority shall independently decide the matter. He thinks because central authority has said it's gospel truth.
If your lordship, then if your lordship, what has fallen from your lordship, if your lordship kindly see page 267, 5.3.8, if your lordship wants kindly see my lord. After considering the facts of the case, including verification report received from the counterpart officer, submission made by the applicant, and the comments, if any, of the counterpart officer on the same, the jurisdictional officer shall proceed to pass a reason order, preferably within. This is not that they have to rely solely on that, but on the point of that.
We will send it back to you. You defy the central authority. You like to know. You defy the central authority. Where is ASG is not here. You defy them. You are the ultimate person, sir. He can only offer comments. If his counter says that the comments are wrong, you defy the authority.
Paragraph 70.
Sir, we are not doing anything to your client, central authority, because you are supreme.
No, we are not supreme. My lord is supreme, my lord.
No.
My lord,
your client is supreme, you are also supreme.
My lord,
This intra-court appeal.
I am relying on of the Supreme Court judgment. If any report adverse to me Even there is no scope of the opportunity in the provision. The opportunity must be
Be
settled.
satisfied with this. This intra-court appeal by the writ petitioner is directed against the order dated 9/6/2025 in WPA 2488 of 2025. The said writ petition was filed by the appellant challenging an order passed by the
State Tax Authority.
Deputy Commissioner of Revenue, Salt Lake Charge, hereinafter referred as the State Tax Authority. Correct?
State tax.
Referred as the State Tax Authority, dated 27/2/2023, by which a transitional credit claimed by the petitioner was found to be inadmissible. The learned single bench non-suited the appellant on the ground of availability of reviewed work. In spite of that, it's coming like this.
Problem is
Non-suited the appellant on the ground of availability of alternate remedy before the appellate authority, and writ petition cannot be entertained. Agreed by the same, the appellant has preferred this appeal. We have elaborately heard so-and-so, Somag Basu, Uday Shankar Bhattacharya, Chakravarti, all names you put. It is a settled legal principle that existence of an alternate remedy is not always a bar for the constitutional courts to exercise jurisdiction under Article 226 of the Constitution. And the Honorable Supreme Court has carved out certain exceptions, one of which is when the authority has acted without jurisdiction. The other is when the order is passed in violation of principles of natural justice, etc. If the facts of the case on hand is tested on the anvil of these exceptions, and if the case falls under any one of the exceptions, the writ court can exercise jurisdiction. The transitional credit claimed by the petitioner has been denied by the State Tax Authority, solely relying upon the verification report submitted by the Central Tax Authority, dated 20/2/2023, sent via email dated 21/2/2023, setting out certain reasons for denying transitional credit to the appellant. The procedure which has to be followed in such cases has been laid down by issuance of a circular by the Central Board of Indirect Taxes and Customs, dated 10th November 2022. The circulars, Mr. Basu, the circular soft copy is available.
Yeah, I can
Copy I can provide. I can
So
provide.
that they need not
I can
type.
provide.
The relevant clauses. No.
My lord, 5.3.6 is in my favor to some extent, because both the official has to.
The circular came to be issued. Circular/guidelines came to be issued pursuant to the order passed by the Honorable Supreme Court in Union of India versus Filco, FILCO, Trade Center Private Limited, SLPC number 32709-32710/2018, dated 22/7/2022 and 2/9/2022. The relevant clauses in the guideline are quoted herein below: 5.3.5, 5.3.6, 5.3.7, 5.3.8. The above guidelines stipulates as to how the State Tax Authority has to proceed pursuant to a report drawn by the verification report drawn by the Central Tax Authority. On going through the above guidelines, more particularly 5.3.7, the state tax authority who has been referred to as counterpart officer, the jurisdictional tax officer, which is the state authority, has independent power to decide as to the admissibility or otherwise of the transitional credit claimed by the dealer, by the assessee, by the assessee. On reading of the impugned order dated 27/2, sorry, on reading of the order impugned in the writ petition dated 27/2/2023, we find that the state tax authority was of the opinion that he is bound by the opinion expressed in the verification report of the central tax authority. The guidelines framed by the CBDT, not the direct taxes, guideline framed by the CBIT&C speaks otherwise. If such interpretation is not given, then clause 5.3.7 of the guidelines would become redundant. And this obviously is not the purpose for issuing the guidelines. Therefore, the state tax authority should consider the report, verification report as of the central tax authority as an information. Furnish copy thereof to the dealer. /RTP, invite their objections, and request for comments to be furnished by the central tax authority on the objections raised by the RTP, and thereafter afford an opportunity of personal hearing to the RTP, and then take a decision by passing a reasoned order. The state tax authority has followed clause 5.3.7 read with 5.3.8 up to a particular point, that is up to the stage of issuing a notice and affording an opportunity to the petitioner to submit their rebuttal, which they have submitted on 24/2/2023. Thereafter, without taking an independent decision on the matter and without considering the rebuttal, without considering the grounds raised in the rebuttal by the appellant writ petitioner, the authority, state tax authority, appears to have been bound over by the verification report of the central tax authority. Therefore, the order passed by the Deputy Commissioner of Revenue dated 27/2/2023 has to be held to be in violation of principles of natural justice and not in accordance with the policy guidelines framed by the central board. Therefore, the same calls for interference, and the writ court would be well within its jurisdiction to exercise its powers. For the above reason, the appeal is allowed. The order passed by the passed in the writ petition is set aside, and the writ petition is allowed, and the order dated 27/2/2023 passed by the Deputy Commissioner of Revenue salt like charge is set aside, and the matter is remanded to the said authority to strictly take note of the guidelines, preferably clause 5.3.5, 5.3.6, 5.3.7, and 5.3.8, afford an opportunity of a fresh opportunity of personal hearing to the appellant writ petitioner, consider all their objections that they have raised, including the oral submissions they may make, as well as the judicial precedents on which they may rely upon, and thereafter proceed to pass a speaking order on merits and in accordance with law. The above direction be complied with within a period of 3 months from the 3 months is sufficient, or 2 months? 2 months from the date of receipt of the server copy of this order.
But I have already sent that circular through email, my lord.
You send it, email that, and you extract.
Grateful, my lord.
We'll stop with that. The resolution is there.
Yes.
Resolution is there, Mr. Chakra. Already, he was mentioning this matter for a long time. And, because keeping this matter pending, it is loss of revenue to the government. You send him back, he'll be caught. Matter is over.